Minister, those convicted in our courts of sexual offences against both women and children are having their records online being wiped away following requests to Google under EU privacy law. Now, Minister, it's completely unacceptable that court reports are being wiped away online, both for the sake of the victims who have had to live with the consequences of those perpetrators' actions and any potential future victims. Those convicted of sexual offences should lose the right to be forgotten permanently.
As the Deputy would be aware on this issue, the data protection regulation is an EU regulation by which Ireland is bound, and the European Court of Justice is responsible for the interpretation of the European law, including the GDPR. So the right to be forgotten, which you've just outlined, is a data protection right which the Court of Justice developed back in 2014 after the Google Spain case. In this ruling, the Court established that users can ask search engines to hide certain URLs from search results when a search is conducted using their name and the content on the page the URL points to includes information that's perhaps inadequate, that it's irrelevant, no longer relevant, or it's excessive. The right to be forgotten affords individuals the ability to exercise control over their personal data. They can decide the information about them that should be accessible to the public through search engines. While it gives people the right to seek the deletion of their data, what it does not do is guarantee that this right will be fulfilled or that this will happen. The Court established in the Google Spain and subsequent cases that the right to be forgotten should not apply in cases to information that's relevant to the public interest, and that includes previous convictions. So it's important to stress there has to be a right there for individuals to apply, and what is clearly set out through the Google Spain case is that it's not an absolute right, and in particular where there is a public interest and that includes previous convictions, that can be refused, that request. The Court ruled that the companies who process the data must determine in each case whether it's in the public interest to retain the data. I want to be very clear in saying that the GDPR does not give convicted sex offenders any automatic right to have their previous convictions deleted from search engines. While it's not open to me as Minister for Justice to change the application or indeed the interpretation of the GDPR rules, I understand the Deputy's concerns, and I'm determined, I suppose, in so much of the other work that I'm doing to prevent serious criminals from hiding their past. And the Sex Offenders Bill, which obviously the Deputy is very much aware of, that's currently being brought through the Oireachtas, will ensure that the systems for monitoring sex offenders is robust. The bill is progressing through the Oireachtas. It includes a number of amendments to the Sex Offenders Register, specifically looking at notification requirements, as well as providing for electronic tagging, prohibition on convicted sex offenders engaging in certain types of employment and other areas as well. Thank you.
Minister, I accept the point that you make, but the reality is that the court system is structured in such a way that convictions are published, that decisions are made and judgments are given in public. And guilty parties should not be in a position where they can request and secure the erasure of this information, exploiting the privacy laws. And this cannot be tolerated under any circumstances. And you're correct, the European Court of Justice decision back in 2014 gives the right to request it, but it also gives the right in the public interest to refuse to actually delete that information. Now, the reality is that the technology companies are not applying that. Once the request is made and that there is a historic element to it, they are actually granting them that right, and that needs to be rejected, opposed and blocked.
Thank you, Deputy. Obviously, the response here in terms of the Department of Justice is that we have to uphold the European laws and the regulations that have been set out. But if there is a complaint, if there is a situation again where somebody feels that information has been removed that shouldn't be removed, then it is within the right of that person, yourself or anybody else, to make a complaint that would obviously be addressed through the Data Protection Commissioner. So the law is there, the law is very clear, the companies are to adhere to that law, and there is a process in place whereby someone can make a complaint if that is not the case. So I think, we have to be able to We have to be able to make sure that individuals have a right to privacy themselves, and obviously I think the vast majority of those who are applying this rule and applying the right to be forgotten, it's information that should be taken down. There are instances where that should not be the case, and it's again up to the companies to respond to the law that's very clearly set out, and there is a mechanism in place for people to appeal that or to make a complaint where they feel that the response is unjust or where the decision is unjust.
Minister, with all due respect, telling people that they can appeal a decision where the information is already taken down is no good. Now, Minister, you sit on the European Council of Ministers. You have your colleagues around the table with you. And I'm asking that you, along with your colleagues, provide clarification and direction to the tech companies right across Europe in relation to this, that point blank, in terms of convictions regarding the assault and rape of children and women and adults in this country or in any other country in Europe, that they will be refused the right to have these records erased. This cannot be allowed to happen. And the only defence that Google is providing at the moment is in terms of the length of time since the information was first put online. They are not carrying out the assessment that you say should be carried out, and it should not be up to the victim to actually have to appeal that. They are the ones that have been abused in the first place. They should not have to be the ones to enforce this.
Deputy, the laws are clear. Guidelines are clear, the companies are to adhere to them. I have absolutely no problem in restating exactly what it is that the companies are to do. Individuals must have a right to be able to apply for the right to be forgotten, but it's very clear where it's relevant to the public interest, including previous convictions, that has to be applied. If companies are not applying, then a complaint can be made. But I'm very clear what the laws are, what the rules are, how the companies should be applying them, and I have absolutely no problem in restating that when I meet with the companies in the coming weeks. Thank you.